Good afternoon. I'm Mary Kate Fitzgerald. I'm the president of the Women's Property Tax Association. Thank you all for joining us today for the start of our three-part series, Methods and Myths of Real Property Valuation for Ad valorem Taxation. If you're an attorney and you want CLE credit, please make sure that you have registered and are watching under your own name and that you complete the survey at the end of this course. We are pleased to announce that we will be bringing you monthly CLE classes. It is a major undertaking, but we are determined to do it. If you have any ideas for educational topics, please email me or any one of our board members, and we'll try to get something going. As you're all aware, property tax has been at the center of much media coverage over the last few years. There seems to be a grave misunderstanding of what concepts we all function under, both legal and appraisal. This series was inspired by our desire to continue healthy dialogues for the improvement of our field and to provide you with meaningful continuing education. The WPTA was founded upon several principles, including education and making educational resources more readily available to all. We believe that sharing information empowers everyone and improves our field. So with that, we will be starting our three-part series. In this first part, we will be exploring the key appraisal concepts with Bruce Darata and Pete Helland. They graciously agreed to present an abbreviated version of their course that they developed and taught at the Appraisal Institute. But before we jump into appraisal concepts, it is important to understand the legal framework under which we are all operating. We will get more in depth in the later series, but for this part, we'll just do a quick overview. Nora Devine will be presenting the legal framework. She needs no introduction. She's the founding president of the Women's Property Tax Association. She started this organization several years ago. Nora owns and runs the Devine Law Group and is active in countless organizations. She has more energy, determination, and vision than anyone I've ever met, and she is a firm believer in mentorship. Nora?
Oh, gee, thanks, Mary Kate, for that kind introduction. We are going to give you all some slides and some materials to give you the legal backbone of the property tax system in Illinois so that we can understand a little bit better the framework within these appraisals are understood. So thank you to Mary Kate, Joanne, and Nicole for helping in developing these slides. And I have about 15 minutes, and then I'm going to turn it over to the real show, which is Pete and Bruce. Here's my contact information if anyone wants to reach me. My main office is in Northfield. I also have space in Chicago. A little bit about my credentials: Loyola University Law School. I've led most of the important groups regarding property tax in the state of Illinois. I teach for the Illinois Property Assessment Institute. I teach about 4 or 5 classes a year, and I really have a great time spending a few days in a classroom with 30 assessing officials from all over the state and just listening to their stories and how they approach problems, and try to remember the things that I learned in order, to benefit the future classes that I teach, and also to help me raise my game whenever I'm trying to represent a taxpayer in the Illinois property tax system. So there are a little bit about my credentials there on that slide. And first, I'm going to start off talking about a couple of the pertinent statutes, and then we're going to cover just a few cases, and then we're also including full copies of the cases in your course materials. And the course materials were a work in progress until yesterday. So if you give us a little time to make sure we have every single case compiled, we will be posting that to our website so that will be available for all the attendees to see. So starting with statutes, we start, as we always do, with the definition of fair cash value, which is the amount for which a property can be sold in the due course of business and trade, not under duress, between a willing buyer and a seller. The property tax code has so many provisions about how assessors are supposed to do their job, how the Board of Review is supposed to do its job, how the Property Tax Appeal Board is supposed to do its job, and we've provided some statutory references there. It's important to note that not all property is assessed pursuant to market value in the state of Illinois. Some of the properties are preferential assessments, such as, the main example is farmland or open space, which is your golf courses and your corporate campuses. Those are not assessed pursuant to what they would sell for on the open market. They have different ways in which they're assessed in the property tax code. And all the correct citations are in your materials. I found that the best resource out there was the DuPage County Board of Review's website. They had a listing of all the different classifications as well as the citations to the property tax code. And then there's certain things that are assessed by the Department of Revenue, which are beyond the scope of what we're talking about today. And as I went through the property tax code to kind of give you an idea of what the property tax code says about what the Board of Review is supposed to do, the best thing I found was the oath of office. It says here, I will fairly and impartially review the assessments of all property to the extent authorized by this code, that I will correct all assessments which should be corrected, that I will raise or lower. So some people don't realize that boards of review have the power to raise assessments as justice may require, and that I will do all acts necessary and within my authority to procure a full, fair, and impartial assessment of all property. So that is the oath of office that you take before you become a Board of Review member. If you look at these statutory citations pertaining to how the PTAB is supposed to operate, Property Tax Appeal Board shall establish by rules and informal procedure for the determination of the correct assessment of property which is the subject of an appeal. And how do they do this? Well, they do it based on facts, evidence, exhibits, and briefs submitted to or elicited by the board. So that is their marching orders. And then when you come to their rules and you think about how they run their hearings and how it pertains to appraisers, PTAB Rule 1910.67 says that if you do submit an appraisal in support of your argument for a reduced assessed value, your appraiser should be there to testify as to how that appraisal report was prepared. When you go to court, this is a statutory citation to the specific objection procedure, also called tax objections. And notice here how it says that it's the court sitting without a jury that will determine the objections. And that's unique to Illinois. The Property Tax Appeal Board has an administrative law judge that would decide a tax controversy, and the circuit court would have a bench trial. So we're not talking about jury trials here in Illinois when we're talking about a evidentiary hearing related to an assessment appeal. Importantly, in court, the assessments are presumed correct, and that presumption is rebuttable. And probably the most important thing on this slide is that last bit there that says that the standard is clear and convincing. So that's a pretty high legal standard to meet. We're going to talk a little bit more about that in a minute. As in now, here is a slide that summarizes for you the difference between the preponderance of the evidence standard of evidence, which is what is going on at PTAB when you're filing based on market evidence, and then at court it would be clear and convincing. So just to recap, the local township assessor or the elected county assessor is responsible for setting the value to a property for a given tax year. Usually there's an informal or formal process at the assessor's office where you can complain about that value and say that it's too high. If you are unsatisfied with the result that you get at the assessor, you can then file at the Board of Review. All 102 counties in Illinois have a 3-person Board of Review. Where you get those Board of Review members varies depending on whether it's a commission county or whether it's Cook County or whether it's other kinds of counties. So after you get your Board of Review decision, if you're still unsatisfied with the value, you can either go to the Property Tax Appeal Board or you can go to circuit court. And there's a big difference between the standard of evidence that's required to prevail at either of these venues. At the PTAB, it's preponderance of the evidence, and we've given you a great amount of detail on this slide as to what that means. And at court, it's clear and convincing, and we again give you a lot of information there. The takeaway from this slide really is that preponderance of the evidence is a much easier standard to meet. If you can imagine like a scale where you put one side's evidence on one side and one side's evidence on the other, you kind of see like which one weighs more, well, then the preponderance of the evidence would be, whoever's evidence weighs more would win. Clear and convincing, is a much harder thing to meet. And if both sides, both the government and the taxpayer, have a fully documented appraisal, it becomes a much tougher road to prevail in Illinois on an overvaluation claim. And, this is one slide that represents what could be a 2-hour presentation on the differences between PTAB and court, but, I tried to summarize the main points as best as I could. The main difference is the first bullet point, which is the, different burdens of proof that you see in 2 different places. There's differences in filing fees, whether or not discovery is allowed. For the appraiser's point of view, for Pete and Bruce's purposes, if the case is pending in court, you may have to suffer through a deposition before you end up testifying at a trial. If the case is pending at PTAB, more likely than not, there won't be any depositions, but there'll probably be significant amounts of prep time before you would be testifying when the trial comes around. Let's see. Quick plug for my friend Ellen. Which is where I got this slide, sort of. I got it because she just recently updated this course called Case Studies in the Appeal Process. She also teaches for the Illinois Property Assessment Institute. They have a spring conference going on the first week of April where you all can go and take a bunch of classes, short classes, long classes. She's teaching this Case Studies in the Appeal Process down there, and I recommend it highly. Cases, moving on to cases. This is the big one. Everyone needs to understand Springfield Marine Bank. This is a case where, you know, maybe in your head you're seeing like a bank building, but I don't think it was a bank building. I think it was just that the title to the property was held in a trust, and that trust was called Springfield Marine Bank Trust XYZ. So I can't remember exactly what type of property this was, but this did go out to the Illinois Supreme Court. This is still good law. This case is cited all the time. And it was a situation where there was a very low market rent, contract rent rather, in place. So meaning that the tenant was paying very little in the way of rent to the landlord. And the landlord very much wanted his property tax bill to reflect the fact that he was not making much in rent on this building. And so he kept pursuing this, and it went up to the Illinois Supreme Court, and the court held that it's the market rent that is supposed to control, not the contract rent. So this case has been read, you know, to mean that basically if there is a discrepancy between what the property would sell for or what the property would rent for in terms of market rent and what the contract rent is actually in place at the property, then you are supposed to be using a market rent rate. So this comes into play in the converse situation where, you know, you have, say, a Walgreens or a big box or something like that, where there's an enormous amount of rent being paid, much more than any kind of rent you'd see on any building that is similar in terms of asking rent. And then what you see is that property sells for an inflated amount of money because that rent is in place. So, you know, the assessing officials have struggled over the years with what to do with these sales. Do you adjust for them? If so, how do you quantify that? So we're hoping to hear from our experts today about their thoughts on that. We also had a case, this will be provided in your materials, where there was a subsidized rental complex, and it was the same thing. The court was struggling with, you know, do we consider all of the rent, including the federal subsidies? The colloquial way to say this is, you know, do you consider all the kick-ins? So you've got the federal government and you've got the occupants, you know, kicking in. So do you consider all of it, or are you just considering what the tenants are paying? And here they're saying when the actual rental income does not reflect the income earning capacity of the property, it may be disregarded. So this is another situation where they want to disregard the contract rent because it's lower than market. But do we also disregard the contract rent when it's higher than market? Because if we do, I mean, if we don't, it seems unconstitutional. If we do, you know, we can end up with, I mean, you can see how it would work, that if we assess the properties based on contract rent rather than market rent, you'd have all kinds of manipulations in the marketplace with tenants and landlords coming to very strange rental agreements that would be impacted by somebody's desire to, you know, keep the tax liability to a certain amount. And you know, going back a slide to Springfield Marine Bank, there's a discussion in this case about how the leaseholds, which, you know, the Women's Property Tax Association just recently did a 2-hour presentation on leasehold assessments and how those are by statute derived. And you know, it's the lease amount is, everybody's very cognizant about what this lease amount will mean for the property tax bill. So it changes behavior. So we have a couple other cases we wanted to point out. This one's called the Omni case. This will be in your materials. This is a Michigan Avenue property that had several different uses included in one building. There was a hotel, there was some office space, there was some retail. I believe there was also some maybe residences, but they may not have been part of the appraisal. So the appraiser did not develop a sales approach to value because they said that the property was too unique and that it wouldn't be practical to try to find sales similar to the subject because there really weren't the same type of sales with the same type of mix between these various uses. So ultimately it did not go well for the taxpayer. They were saying that the appraisal was insufficient as a matter of law. So I always get nervous when appraisers want to not put the cost approach in a report, just because this case is out there and it was hasty and I didn't think it was that well reasoned. But it's out there. And then the counterpoint to that case is the landfill case. And this was where the appraiser testified that the income approach would be unreliable given the full financial information on the available sales comps. So basically it's saying you don't really need to develop a sales approach on a landfill because the value is really tied up in how much more capacity is left in that landfill. There's a brand new case that's included in your materials. My friend Dave Duncan is the one who took it to hearing or pursued the case. I'm not sure if it went to a full-blown hearing or not. This was like a 46-unit building that was gutted and converted to condos. And I guess they had pursued vacancy relief at the Cook County Board of Review for some of the units that were demolished and being rebuilt. And it didn't work out. So they filed a PTAB, and PTAB, the taxing district got involved and said, well, here's a line of cases, like 5 cases or so, that said, oh, you can't, PTAB doesn't believe in vacancy relief. And so this case came out different than the prior 5. And this case came out that said, well, this really isn't a vacancy case so much as it's a diminution in value case. So that's a really good, worthwhile, brand new case that's worth looking at. And if you have a building with similar facts, you definitely want to acquaint yourself with how the PTAB approached this. This is Ellen Berkshire's case. She represented Sears downstate in Bloomington, and she hired an MAI appraiser. She had the client hire an MAI appraiser, and they filed based on appraisal evidence. And the appraiser had used anchor stores from different jurisdictions, including other states. And the government had engaged an appraiser to write a land-only report. And the thinking there was, what are you talking about that this thing is only worth X dollars per square foot of building value, land included? Here's an appraisal showing that the land alone is worth more than that. So the PTAB sided with the taxpayer on this one and said, this appraiser was credible and we're going to go with that appraisal. So that is a good case to know about. And I mean, you got to include a poem, right, with every presentation. This is how this case starts. Wells versus Property Tax Appeal Board. This is out of Tazewell County. This what I call the sale chasing case. Everyone knows that sale chasing is illegal, right? So we'll talk about that in a second. So here's the poem. His horse went dead and his mule went lame and he lost 6 cows in a poker game. Then a hurricane came on a summer day and blew the house where he lived away. An earthquake came when that was gone and swallowed the land that the house stood on. And then the tax collector came around and charged him up with a hole in the ground. So this case was about how the local township assessor was only reassessing things if they had sold. So in other words, they had not done an in-depth reassessment or reappraisal of this area in quite a while, and they were basically just waiting until something sold, and they were saying, aha, this is what it's worth, and then they would put the value at that. So over time, this resulted in, several houses being assessed way higher than all the other properties in the neighborhood codes. So, the court said you can't do that. You have to actually every so often go through and do a mass appraisal system, because otherwise you lose uniformity, and the Constitution requires uniformity. So this is the case that stands for the proposition that sale chasing is not legal. Cunningham versus PTAB. This is in your materials. I think this is another income case. I don't have it in front of me right now. 1411 North State condominium versus PTAB. This is the what to do if your appraiser is unavailable. In this particular case, the appraiser passed away, and I believe the situation was the PTAB was wanting the case to, go nowhere because there was no appraiser that could testify as to how the appraisal was put together. And the appellate court said, no, you got to give, the taxpayer an opportunity here. So just best practices, just a practice pointer for everybody is, you should have more than one person signing your reports. If you're looking at a situation where you're having a taxpayer commission a fully documented appraisal report, you would want to make sure that that somebody's going to be around in 2 or 3 or 4 years when this case comes up for hearing. So things change. People leave their jobs, or people retire, or people pass away, as is the case in this case. So having more than one signature, having a group approach to putting reports together is always advisable, because these rules can be strict and difficult to get around if the person who signed the report is no longer available. So current government processes, we have all of the vacancy requirements are in your materials. It's changed over time. It's getting more difficult to get vacancy relief. There's no specific case or statute that says that people are automatically entitled to vacancy relief if their property is vacant. But for as long as I can remember, Cook County and most other counties have had an equitable policy where they will reduce a building value for a time while the taxpayer is trying to get their property back into full economic use. And these requirements are changing and becoming more strict, and the PTAB's approach to vacancy, is changing a little bit too, if you look at that recent decision that we included in the materials. So generally, what are we looking at? What documents are required today? For the Cook County Assessor's Office, they want this RPI form for any kind of income producing property. RPI, Real Property Income and Expense Form, I think it stands for, and it's not really a form that you can fill out in Adobe and upload, although some firms are doing it that way. It's like a portal. It's more of an online web page, and you put in the data for your property. And if you don't know some of the information, or if you can't fill it out, then you can't submit it. So it is a little bit fraught. It's hard to deal with the form, and it takes some time. But from what I understand, if you fill out 1 year, it's the effort that's involved in filling it out, and the subsequent years is supposed to be greatly improved. At the Cook County Board of Review, they are looking for a printed rent roll. They are looking for 3 years of profit and loss statements. And then once you get to the Property Tax Appeal Board or the Circuit Court, effectively you need an appraisal. If you don't have that appraiser, it works best if there's an advocate like me and there's an expert like Pete. If I show up and I try to be the advocate and the expert, it doesn't go well. It doesn't work well. If Pete tried to show up trying to be both the advocate and the expert, it also wouldn't go well. So I think the system is good at finding the truth of the matter. And that's what the adversarial legal system is all about. In basically Western civilization, you have your advocate, you have your experts, and then you try to figure out which side of the story is more true. I'd like to add this in. This is the Lake County Board of Review's income sheet. They put it on their website, and if you have an income producing property and you appeal it in Lake County, they like to see you fill out this form. And I like that they're offering suggested cap rates. So, I think the Board of Review of Cook County used to have a chart where they would, have different cap rate ranges for different parts of the county. I asked if anybody's seen it lately, and someone was like, "Yeah, I think it's just an 8 cap pretty much all over the place." Whether it's so this is this is not varying by location. I would assume that cap rate in Waukegan would be different than a cap rate in Deerfield, but basically it's just various cap rate ranges based on the type of property. But something worth considering if your jurisdiction wanted to put some kind of tool out there for your income producing properties to try to bring you their income and show you what's going on with the property. Legislation, we have a few legislative proposals that are worth mentioning. Some of them had legs, some of them still have legs. Things are changing by the minute, so who knows? Some of you probably have more current information than I have, I'm sure. But this was House Bill 4974, and in addition to something about the IDOR doing a sales ratio study, it was basically intending to keep an increase held to no more than 15% per year. So, some of these values, and we're seeing in some of the commercial properties inside of Cook County had, 100% increases, 300% increases. So, this kind of thing, I don't know if this is just for commercial or if it's for residential. It seems like, nobody really is trying to do anything for commercial properties right now, but assuming this would apply to both commercial and residential, it would hold that increase to 15% per year. And importantly, this is the abolish PTAB jurisdiction in Cook County bill. It also says that every single appraisal filed at PTAB would have to be compliant with USPAP. So I've heard from some smart assessing officials who say that that would actually have more implications for the government side than it would for the taxpayer side, because the taxpayers are already submitting USPAP compliant reports, and what the government is currently submitting, it would not be USPAP compliant. So I assume that there's a lot of government types that are weighing in on that and trying to help the legislators understand how that would actually impact the kind of work product that they submit to a PTAB hearing. So far that's been referred. So who knows if it'll, property tax subcommittee, this is like a subcommittee of the revenue committee. So who knows if we'll see that or if it's dead. Pending legislation 5335, USPAP compliant, abolishes PTAB, that's the same thing. Senate Bill 3895. This is going to revolutionize the way that low-income housing is assessed in Illinois. The low-income housing lobby is very excited about it. So if you represent a lot of low-income housing clients, you would want to check to see how this works. And if you have a lot of low-income properties in your jurisdiction, you want to pay attention to this bill to make sure that you're adjusting with the times as the law changes. This is a companion bill, and this is the vacancy fraud bill. I think this thing is still alive. Second reading as of February 17th. And, it's the situation where you're walking down your street, and this is mostly a Cook County problem because vacancy relief has been less meaningful and harder to come by in counties other than Cook. But inside of Cook County, there's certain, neighborhoods where they've got vacancies, and it just seems like the owners really aren't that motivated to actually do anything. Perhaps they're holding the property through another couple of real estate cycles until they can catch an upswing in the market, or and then sell at that time. And they're, in the meantime, they're just trying to drive their carrying costs as low as they can. So the communities are reacting to these eyesores in the community, and they don't want it anymore. And they figure that the best way to end this is to try to criminalize this failure to do enough to get your property leased up, if that makes sense. So, and then the people who are against it say, oh, it's duplicative. There's already, there's already penalties for fraud. There's already penalties for lying on any of the forms that go into the board of review. So we will see if this thing moves forward or not. And, I would just reiterate that the vacancy relief in general has really become harder to come by and less meaningful in general, even when it is obtained. So I think this problem seems to be sort of taking care of itself in my mind, but it's, as a former resident of Bucktown for 10 years, there were certain addresses that used to drive me nuts. So I do understand the sentiment. And this was ripped from the headlines just this morning. I got this in my email box. And this is just sort of my way of transitioning my portion of this talk over to the real stars of the show, which is Pete and Bruce. So Cranes was talking about Northbridge, which is where the Nordstrom is on the Magnificent Mile near the river. And if you read the couple of articles about Northbridge, it was saying right now what's happened is one partner traded their 50% interest to the remaining partner, and reading the tea leaves, it means that this property is worth $417 million in 2022. Now, you know, they make a lot of leaps of faith to get to that number, but let's just write it down, and which I've done on this slide. And then if you look, in 2008, they purchased it for $515 million. And Cranes reported that that number incorporated the anticipation that the tax bill would increase by $5 million due to the reassessment. So, and then in that same article, they say, well, back in 2003, we seem pretty certain that it was worth $315 million. So if you just assume an equalizer of 3 and a tax rate of 7, just round numbers, you know, you're talking about in 2003, the tax bill should have been $16.5 million. In 2008, it should have been $27 million. In 2022, it should have been almost $22 million. You know, how do you make sense of these numbers? You know, is the assessor supposed to go to the 515 million when that sale occurs, even though 10 years later it may be worth 100 million less? Was it ever really worth 515 million? Like, when you peel back the onion on some of these big sales, what's really going on? And even Cranes is reporting about how a lot of these purchases are tied in with a bunch of refinances and their ability to borrow and their ability to do things with other properties. So, I mean, you know, hopefully our appraisers can shed some light on, as a valuation question, what are we supposed to do with this broad of a number? So what is the appraiser's role legally? In America, we used to have this standard called the Frye standard, and the Frye it references a case. And the idea is that scientific evidence is most often presented in court by an expert witness testifying on expert opinions. And it also includes expert testimony that goes beyond science. The scientific expert is frequently called upon to interpret results and draw conclusions about what results mean in the case being tried. So we have today Bruce and Pete, and I'm going to let Sue introduce them more in depth. But if you were to use experts, MAI appraisers, in your case regarding assessment controversies, you know, in a lot of states, you'd have to worry about what standard are we using? Are we using the Frye standard, or are we using the Daubert standard? The Frye standard only applies to new or novel theories, and it's whether the proffered testimony is generally accepted in the scientific community. And in this case, neither one of these guys would have a problem under the Frye standard because they're both MAI appraisers. That's the highest designation that you can receive from the Appraisal Institute. They're in good standing. Not only are they, not only do they carry that designation, they're also teaching classes for the Appraisal Institute. So neither one of these guys would have a problem under the Frye standard. The Daubert standard became this question of, should the judge be acting as more of a gatekeeper, in terms of hold these experts' feet to the fire to make sure that what they're talking about is legitimate before the jury's allowed to hear it. And, in the personal injury context, if you look at the landscape legally, Illinois is more of a Frye jurisdiction. And then a lot of the others have become more of a Daubert jurisdiction, where the judge is deciding whether or not an expert is worthy enough to be heard by the jury. And as we discussed before, it doesn't matter that much because in Illinois, it's an administrative law judge that's making the decisions at PTAB, and in court, it's the judge sitting in a bench trial. And at the Board of Review, it's a quasi-judicial administrative agency, and it's usually deputies and things like that that are actually hearing the evidence and making the determinations on behalf of the commissioners or the Board of Review members that they work for. So not as much of a consideration. I'm going to introduce Sue Ulman. She is a founding board member of the Women's Property Tax Association. She got her BA from U of I. She's also an MAI. She's, I think, our only appraiser on our board, and we love her. And we see she's also got all these other designations, and I'll let you read her bio. She's a member of crew. She was doing all of our volunteer work with us for the Women's Property Tax Association, and now I think she's moved on to treasurer. And I'm going to let Sue introduce our stars of the show. And Sue, you can take it from here.
Good morning, everybody. 2022, it is my pleasure to introduce two exceptional experts. First, I've got Pete Helland. He is an MAI. He is an AI-GRS, which is the review designation. He's the treasurer of our local chapter of the Appraisal Institute, and he has been appraising for a number of years. He's with Newmark Valuation. He does appraisals, internal reviews, expert witness testimony, litigation support, client outreach, business development, internal support, and review assignments. And he's done these things throughout the Midwest. He's done a number of property types, and before that, he's been with some other Midwestern firms. I'm keeping my intros very brief because these guys can stand on their own. After that comes Bruce Darata. He is president of our local Appraisal Institute chapter. He's an MAI. He is a member of ICAP and the Fox Valley Realtors Association. He's done appraisals and work for assessing bodies. He's on the DuPage County Expanded Board of Review, and he has worked on also many types of properties and seen a lot of different things. Between the two of them, they have done a number of classes and have over 45 years of appraisal experience and have thought all these issues that we are beginning to think about or in the middle of thinking about or continuing to think about regarding tax assessments. And without further ado, let me turn the screen over to Pete and Bruce so they can give us further insights.
All right, Pete, you want me to start off here? All right, sounds good. Well, thanks for having us. It's a real honor to be able to speak with this group. Just to give you a little background, Pete and I kind of got to know each other through this assessment process. Not only have we been working together as board members with the Chicago chapter, but we also have sat across the table from one another many times during Board of Review appeal sessions. And as Sue mentioned, I'm actually on two different boards of review. I've been with DuPage County Board of Review as an expanded member, and I'm also on the Kane County Board of Review as an expanded member. So we've had plenty of opportunities in both counties to interact. And I think we started talking about developing this class probably about 2.5 years ago. We both kind of identified a need in the market. We would see lots of appraisals and lots of appraisal concepts being thrown around, not necessarily in the most appropriate way. And we felt also that this was an interesting topic that many of our colleagues would want to learn more about. So that's kind of the background of that. Pete, can you go to the next slide? So as I think Sue mentioned, I'm a fee appraiser. Oh, we're going to skip that. Okay, we already did all that. So the objectives of the class is to understand the uniform standards of professional appraisal practice relevance and the impact on the ad valorem process. We're going to talk about intended users and intended uses. Again, those are terms that are used quite a bit, but we're going to do kind of a deep dive into those, into what that really means. We'll talk about the key differences between ad valorem and financing appraisals. Many of us appraisers do finance work for various lenders, but ad valorem is kind of a whole different, it's a whole different way of doing things as opposed to that. And then we'll also gain a little insight into what the reviewers are looking for. So when you're writing an appraisal report for an ad valorem type situation, what are the assessors going to be looking at? what are the county boards going to be looking at? If it goes to PTAB, what are they going to be looking at? Those are important things to keep in mind. And then key components that'll be present in every tax appeal appraisal. Okay, so we talked about this a little bit. So I've been a full-time commercial appraiser since 2009. I earned my MAI designation in 2013. Our family business has been around for over 30 years. I started working with my dad in the early 2000s, kind of on a part-time basis, and then went full-time in 2009. And when he retired, took over the business in 2013. I already mentioned my work with the boards. I'm the current president of the Chicago chapter. And I think that's it for that one. Let's go to the next one, please. Pete, you want to speak?
Sure. I've been doing appraisals. I started in 2005, exclusively been doing commercial work that entire time. Really got into the assessment appeal side in 2009, as I'm sure a lot of people did after the most recent real crash of the commercial real estate market. I've done testimony at all levels throughout the state of Illinois, including PTAB, both in person when we used to do those, and now mostly virtual. Hired 4 assessment appeal narrative appraisals across 9 states in the Midwest. So that's most of them outside of the Dakotas at this point. Pretty much, like I said, I only do written narrative appraisals, also write reviews for litigation purposes. And I just want to hammer home one thing that Bruce has already mentioned about developing this course is, we've sat across the table from each other, yet at the end of the day, we both work together to develop this course, meaning we have the same idea of what is necessary and what should be done. So I think that gets glossed over sometimes, thinking that if you work for this side, you should be doing this, and if you work for this side, you should be doing something different, and that's not the case.
Yeah, that's a good point, Pete. At the end of the day, we want a fair assessment. That's in the best interest of everybody. And being on the board of review we're all supposed to be unbiased, but we're not on any particular side. Sometimes we have appellants coming in and they're talking about their taxes and how high we make their taxes and stuff, and so we have to explain to them. I'll go into that a little bit later, but we're not the ones determining the taxes, first of all, and secondly, what we're really interested in is making sure that assessments are fair and equal. So I'm just going to dive right in here. So I want to do a quick overview of the property tax cycle and the appeal process. Many of you might be already aware of this process, but I'll just go through it quickly. The assessment cycle begins with the creation of the assessment books and ends with the review of the assessments by the Board of Review. So it's going to start with the actual assessment, review, and equalization. During the assessment process, there's 4 steps. We identify the real problem within the jurisdiction. Listed on the assessment rolls, actually assess the property and then place a value on it for the tax rolls. And here's your property tax cycle, kind of reviews most of what I already said: the assessment process, the review of assessment decisions, a state equalization factor, the taxes will be levied, that goes to the extension and collection and distribution. And here's the property assessment administrative cycle. The county clerk will deliver 2 sets of real estate assessment books to the chief county assessment officer by January 1st. They'll meet with the township assessors, establish guidelines, and then the assessor's set to determining the value as of January 1st. That gets returned to the chief county assessing officer. They review it, equalize it within the county, publish the changes, and deliver the books to the Board of Review. At that point, the Department of Revenue will develop a tentative equalization factor, and the Board of Review will hear complaints and make changes when necessary. So that's when Pete and I get involved. Once that process is completed, the county clerk will prepare the final abstract of assessments and mail to the Department of Revenue. Then the Department of Revenue will certify the equalization factor to the county clerk, and it'll be published. The county clerk will apply the equalization factor, and the Department of Revenue certifies state assessments and mails to the county clerk. Okay, so as I stated earlier, there's a lot of definitions involved in appraisal practice that are used a lot, and maybe everybody doesn't have the same understanding. These are all the definitions from the appraisal dictionary and from USPAP. So ad valorem refers to according to value. Assessed value is the value that a property has after multiplying the market value by the level of assessment. So most of us out here, I'm in Aurora and Will County, Pete's up in Kane County, we're all at a 33 1/3% assessment level. In Cook County, as many of you are aware, I think it's either 10% or 25% depending on the property type. The intended use is the use of an appraiser's reported appraisal or appraisal review assignment results as identified by the appraiser based on communication with the client and the time of the assignment. So we're going to break that one down into the various terms used in that definition and kind of do a deep dive into that. And then the intended user is the client and any other property as identified by name or type as users of the appraisal or appraisal review by the appraiser based on communication with the client at the time of the assignment. So let's talk about intended use. We're going to talk about assignment results identified by the appraiser based on communication with the client and time of assignment. So assignment results, those are the results that are directly tied to the assignment. It's outlined in the engagement letter and the scope of work. I also want to point out here, the scope of work is identified by the appraiser as well. The client does not determine what the scope of work is. In other words, the appraiser will decide, what level of research is going to be used in the report, what approaches are going to be used, which ones are not going to be used, and the reasons why. The other component of intended use was the identified by the appraiser. And what we're talking about here is the appraiser is going to determine and identify the intended use. The intended user or an independent third party is not going to do that. It's solely determined by the appraiser in communication with the client. So once the appraiser speaks with the client about their intended use and users, that's all going to be spelled out, and it's all specifically going to come from that communication. And then the time of the assignment, all these factors are outlined at the time of the assignment. If anything's altered after the completion date, it's a contrast with USPAP. So a lot of times what I see as a Board of Review member is an appellant will submit an appraisal that's 2 years old. Or they'll submit an appraisal that had a completely different intended use. Maybe the owner of the property had the appraisal done for a loan purpose through the bank. Those are kind of examples of where an intended use or intended user is not appropriate for the use at hand, which is for ad valorem assessment appeal. So let's do the same thing with the intended user.
Real quick, Bruce,
Mm-hmm.
To piggyback off of that. Now, how is it viewed when the assessor pulls one of those and presents that at Board of Review?
Well, I mean, any evidence that's presented to the Board of Review has to be considered. I'll never say we're going to throw anything out, but certainly if no matter which side presents the evidence, if it's not the proper intended use or intended user, it's going to be given a lot less weight in its determination. So.
Thanks.
No problem. So intended user, kind of the same thing. We want to break down these different terms. Pete, if you can go to the next slide, we can break that out. So the client, the entire report is directed to and centered around the appraiser and client agreement. When people ask me what a client is, what I tell people is the client is normally the person that engages me to do the assignment. Oftentimes, they're also the ones paying the fee. That's not necessarily always the case, but the client is the one that actually contacts us and asks us to do the assignment. Any other party is identified by name or type. So the appraiser is going to determine any additional intended users. The client that is involved, he's aware of these these additional parties. They have the full rights to the appraiser, and the appraiser must know their knowledge level and write the report to their understanding. So, you know, if I'm writing to somebody who is a valuation expert, I may not have to define every little term. It's assumed that they know what ad valorem means and use PEP and things like that. If I'm working with somebody that may not be as familiar with those types of things, then we're going to spell those types of things out. If a party's not identified, then they really have no right to utilize or rely on the appraisal. So that's what I was touching on earlier. Technically speaking, as a fee appraiser, if I write an appraisal report for XYZ Bank and then the owner of the property gets a copy of that appraisal and uses it for ad valorem assessment appeal, that's an inappropriate use. They really have not been authorized to use that appraisal. The appraisal is actually owned by the bank. Communication with the client. The users of an appraiser's results are communicated to the client at the time of the engagement and the time of the assignment. That's all the parties. All of these parties are determined at the time of the assignment. Altering any of these uses after the completion is in clear contrast with use PAP. So other parties identified, the appraiser determines and identifies additional intended users. The client is aware of these users. Again, you know, if those users are not identified, then they're not authorized to use or rely on the report. We have to be really careful in naming PTAB as the intended user. Is our intent really to pass the full rights of use of this appraisal to this party? You know, if you're going to do that, then I guess it's important that the appraiser knows that they're writing specifically to their needs. So an example would be an additional jurisdictional intended user, given the purpose and intended use of the appraisal report is the Minnesota Tax Court within the scope of appraisal of appeal proceedings. If you're going to identify the assessor or board of review, the same situation applies. Competency of these parties varies. You can include, you know, farmers, residential appraisers, etc. If it's an intended user, they may try to use this appraisal as evidence in other cases. So I guess the bottom, you know, kind of the bottom line is be careful who is identified as a potential intended user or added users. So mass appraisal, basically, as an example, kind of about where I live in the Aurora Township, I think there's over 30,000 properties. Obviously, the township assessor isn't going to go around and appraise each property individually. Mass appraisal refers to the process where they're going to determine through the application of mass appraisal techniques to value a group of properties as of a given date. They're going to use common data, standardized methods, and statistical testing. So the role of mass appraisal is to allow the assessor to be able to apply an assessment value to a large group of properties at one time. So some pitfalls with the process. Obviously, every property is unique and individual. There can be issues with, you know, if you're doing a mass appraisal, for instance, if you live in a neighborhood full of homes and the homes are all somewhat identical or close, you know, close enough to each other that an assessor might kind of look at it overall at the same time. And, you know, there might be some differences. For instance, maybe one house has a finished basement, maybe another house has a 3-season room in the back. Those types of things aren't necessarily going to be caught by the assessor because he's doing a mass appeal process. So that's where individual single appraisal reports will kind of bring those things to light. If there's any lack of uniformity in the neighborhood for those reasons I mentioned, I mean, those things can be brought to light and some adjustments can be made. So some common pitfalls of appraisals submitted for tax appeal evidence. These are things that Pete and I have seen over the years, common mistakes that we've seen appraisers make that will affect their ability to be able to, properly present their case for their appellant. So not using sales within the accepted period of the evaluation date. I believe most counties, at least ones I've worked with, that's January 1st of a given year. But it's up to the appraiser to check the county's Board of Review rules. Nobody is saying that you have to use sales within the neighborhood. Now, when we talk about neighborhood, more times than not, that usually applies to residential properties. If I'm doing an industrial building, I don't think there's any reasonable expectation that I'm going to find 4 or 5 industrial sales all in the same industrial park or neighborhoods, so to speak. I think it's reasonable that we try to find the sales that are most appropriate and closest as we can. But oftentimes what I hear assessors say is, they have these neighborhood designations. So your neighborhood designation might be 08 or something like that, and there might be some sales in the neighborhood. That's okay if the appraiser has decided to not use those, but I would highly recommend that if there are sales in the neighborhood as delineated by the assessor, that you at least acknowledge those sales and explain why or why you may not be using those sales in your grid analysis. I kind of touched on this earlier, but not having a valuation date of January 1st of the given year. I just got finished with the DuPage County Board of Review. We had several appellants that had presented appraisal reports from January 1st of 2019 when they're really trying to argue January 1st, 2021. So obviously markets can change. Using an older appraisal report doesn't really benefit anybody. Incorrect intended use and user, we've spoken about that already. Inappropriate gross living area adjustments. Sometimes with form reports, the form reports are exactly that. We're clicking boxes and we're putting information in, and it can be a very effective way to appraise a residential property. What I find that's missing oftentimes is the support for the adjustments. So I would advise to take the extra time and show the derivation of those adjustments. Maybe it's a linear regression, or maybe it's a paired data analysis, something like that. Put that in the addendum. It'll be much better supported for your appellant. We see appraisals, that at least appears to us that maybe the appraiser is somewhat of an advocate for the client. And that's something I have to explain to people all the time. Lawyers are advocates for their clients. Appraisers are never advocates for the client. That's kind of hard to explain to people sometimes because, after all, if the client is hiring you to do something for them, they want it to be able to benefit them, and that's completely understandable. But at the same time, it's our job, in order to engender the public trust, that everything we do is unbiased. We don't have any kind of advocacy at all. The only advocacy we have is for our own value. I also see appraisal reports submitted with too many differences in construction attributes. So again, using residential as an example, if our subject is a 2-story, well, let's say our subject is a ranch building, and we're using all comps that are 2-story. Generally speaking, it's more expensive to build a ranch on a per square foot basis, so that wouldn't necessarily be the best comparable. And to be fair, some township assessors, they do it the opposite. They'll use a bunch of ranch comparables to compare to a 2-story, which tends to elevate the assessment slightly. So other attributes we find: brick versus vinyl siding, size differences, number of plumbing fixtures, those kinds of things. So we try to pick comparables that are as close to our property as we can. I often see evidence submitted on both sides with large age differences. That's going to make a big difference. Sometimes, going back to my example with industrial buildings, people don't build industrial buildings in general with 12 or 14-foot ceiling heights anymore. So if I have a building that's got 14-foot ceiling height and the assessor shows me all comps with 30-foot ceiling heights, there's probably something, what appraisers call functional obsolescence. There's some functional obsolescence in the subject that's not being captured by these comps. So again, it's important to make sure that not only construction attributes, but age, because age can, what comes with age oftentimes is functional obsolescence. Failure to inspect comparable sales. I review a lot of reports where people use pictures that they obtain from either MLS or CoStar. That's fine. I would advise an appraiser not to do that. I can't tell you how many times I've found what I thought was the perfect comp, and especially in Chicago, where they're repurposing, in certain neighborhoods, they're repurposing industrial buildings. Either they tear them down and put apartments there, or maybe there's a brewery there in its place, but the highest and best use is no longer the same. And if you use a picture, CoStar doesn't necessarily take that level of deep dive into these properties. So an industrial building might sell with the assumption that the continued highest and best use is the same, when in fact, you drive to the property. I've had it happen where I've driven to a property, it's completely leveled, it's gone, all I see is dirt. So one other example I can think of, I think it was at DuPage County, it was an MAI appraiser, I don't remember who it was, but they had submitted an appraisal report showing I believe it was a gas station. They were trying to make an appeal for a gas station appellant, and it turned out that gas station had been torn down after the sale, and an office building was there in its place. So by not inspecting that property, they've really picked a property that has a completely different highest and best use from the subject. And I've already touched on unsupported adjustments, but again, when we make adjustments in reports, we need to make sure we show our support. So I believe this is the last slide. We wanted to give you an example of an assessment appeal process. You can read through this yourself, but basically the gist of it is that that the proof of market value was not proven because inappropriate comps were used. So the board found that the best evidence was an appraisal submitted by the appellant, estimating the subject property at a market value of $166,000. They developed a sales comparison approach using 5 sales of unimproved residential properties located in the subject's market area. Now, the appellant adjusted the comparables for differences from the subject property which appear reasonable. The assessment that was in place had a considerably higher value, almost twice as much. And there was less weight given to the Board of Review sales. So this is kind of going back to what I was talking about with the highest and best use. I see this a lot. Sometimes appraisers think land is land. Well, land can be kind of difficult to appraise sometimes because it seems simple. You don't have an improvement on the property. You're basically appraising dirt, but that's not really, there's a lot more that's involved in it. And what it came down to here is the Board of Review had used a bunch of comparables that had a different highest and best use. They used commercial land sales, trying to compare to the subject's residential sale. They used a listing. Listings are fine, but they're not the strongest indicator of value. And then I also believe there was a assemblage sale where there were 2 parcels purchased together, which can affect the value somewhat. If a user wants to combine 2 different parcels, oftentimes they're willing to pay more for that, because if they really need those 2 parcels together, they can't buy 2 parcels that are apart. They're going to have some value by combining them together with an assemblage type of value. So in this case, the Board of Review did not win their case because the subject's assessment was deemed appropriate by their appraisal with more appropriate comparable sales. So I think that was it for my part, Pete.
Thanks, Bruce. All right, I'm gonna kind of walk through start to finish the commercial appraisal process for ad valorem purposes. And along the way, I'll try to point out some things that might be different from financing appraisals. I know that's a hot topic right now in the industry, and differentiating between those, and also just giving a general overview of what we're doing on our end. And at the end, obviously, we'll be open for questions. So if you want to write those down along the way, we'll be happy to answer those. So the engagement process, the request can come from, and we kind of touched on this with the intended use and intended user. Could be the property owner, could be a tax rep, could be the attorney specifically, a tenant in a property, right? If I'm on a triple net lease and I'm responsible for paying the taxes, then a lot of times I'm also responsible for appealing the taxes, because in certain circumstances, the landlord might not really be interested in worrying about what I have to pay for taxes. On the flip side, the assessor in a given township could request an appraisal, right, and appeal it directly. The county board, the board of review, as we talked about, they could be the one that requests an appraisal. Also, the school district and their intervening attorney, if it were to go to PTAB, could eventually be the one making an appraisal request. So there's a lot of potential clients in this genre of appraisal. And again, this is kind of reiterating what we went on with the intended use. You need to understand the full scope of the assignment, including the property and the issue at hand prior to engagement. And this is really important for everyone involved, not just the appraiser. I've had plenty of assignments where it turns out the appeal included another site that they didn't, engage in. And when I say site, another parcel. And on the flip side, it's gone the opposite way, where throughout the process, it's like, I don't know, should we only be appealing one of these parcels? Do we want to appeal all three? So really fleshing that out at the beginning before the engagement takes place is the best time. Nora touched on this. We want to be mindful of relevant case law and local definitions of value. I mentioned earlier the number of states that I work in, right? I need to know the differences. Easy one. I think all of us here in class today are based in Illinois. So right next door, Indiana is market value in use. So it's very important. They take it very seriously that the sales were still used for the same or very similar uses after the sale, or they kick out those sales. So understanding that definition. Some states are not as specific in their definition of fee simple status as Illinois, where Illinois it's pretty basic. Market rates, market occupancy, right? And we'll get into that more later in terms of understand each property type, understand what goes into that. If you're appraising an apartment building for fee simple, that doesn't mean it's empty, right? It's market occupancy and at a market rental rate. We don't want to penalize people for getting above market rates for however that worked out for them, and we also don't want to give people credit, again, as Nora pointed out in a similar case, for not achieving the rents that they should be. Any potential testimony that's going to be included, it's good to get that out in the engagement as well, and how that's going to be handled. The valuation is always going to be fee simple in nature with a retrospective valuation date. And as the appraiser, as Bruce pointed out, our job is to remain independent. There should be no contingency fee for any of these assignment results. So competency, that's come into play for a number of my clients, and speaking with them. They will find a very, even a designated member of the Appraisal Institute who is very competent in a property type, and maybe they even specialize in that property type, but they haven't done any ad valorem work. So maybe they're completely competent in one aspect of the appraisal assignment and not in the other. Now, does that mean they cannot become competent? No, not at all. But that needs to be disclosed up front, and they need to show how they became competent along the way. There are litigation course series through the Appraisal Institute that we offer that can help people become competent. IAAO, IPT, earlier today it was mentioned IPAI, courses like the one we're having here today. All of those can help people gain competency and understanding. Again, geographical, litigation-based, property type related, there are a lot of layers to competency that's going to help you throughout the process to have the best expert witness you can for PTAB or Board of Review or any appellate courts. The skill set, this is a much more in-depth appraisal. One of the skill sets that is very important here, I'm going to piggyback off of something Bruce just touched on 2 slides ago. Fleshing out your adjustments. First of all, making them, right? I think we've all seen an appraisal that's been submitted for appeal purposes, whether you've reviewed it or, you know, however it came across your desk, where there are no adjustments at all. So that's a bad start. We've seen others where maybe we have pluses and minuses, or double pluses or double minuses, or maybe we have a gross adjustment, not a net adjustment, or we have both, or we have individual adjustments along the way. However it's handled, it needs to be supported, right? And something needs to be done to let the reader and the intended users understand how you got there. Also, in these type of narrative reports, they're typically more lengthy. You're going to need to be able to write, right? You want to have someone that's very competent in developing the writing skills, fully explaining things, explaining the market, explaining the highest and best use, and all those layers. And a lot of these, again, these PTAB cases are publicly available. And I believe the same goes for Board of Review. Is that true, Bruce? If something gets submitted to the board, is that publicly available?
The appraisal reports, you mean, the actual evidence?
Right.
I
Or
don't
is it
think,
just PTAB?
yeah, I don't think all that is publicly available. You know, the results and the, you know, what was talked about in the case and stuff like that. I think there's minutes. The minutes are publicly available, but not the actual evidence.
Sure. So those are things to keep in mind when you're going through these cases and understanding what you're submitting and being comfortable with it. The roles, I'm going to skim over this really quickly because Bruce already touched on it. The appraisers are independent. It's an independent third party. One thing that is a little different here that I added, the difference between market value definitions at the state level and opinion papers. There'll be some examples we'll get to later in the presentation, but differentiating between those two and knowing where the yard marker is at the end. And then the attorney is the advocate, right? There's no disputing that. The appraiser should be independent. Why is an appraisal involved? Maybe a settlement couldn't be made, lack of necessary data either on the assessor side or the appellant side. There are other legal proceedings involved. You know, I'm sure Bruce has been part of situations at the Board of Review where there's already pending litigation on the property and they came in maybe for year 3 at the board level. And, you know, it's not that they didn't see compelling evidence, but they don't want to step on the pending legal proceedings. Would that be accurate, Bruce?
And that's absolutely right. We'll either try to work something out, some type of 3-year deal or something, or if we're not at that point, then it'll be confirmed.
So we went over the potential clients and how that process works. Now, common disputes, as previously mentioned, uniformity. I just included an example of one that I've worked on in the past. This was a case that I had on an anchor, a mall anchor out in Kansas, where, no, excuse me, this is in Wisconsin. But anyways, as part of my process in developing my appraisal, I checked on the assessment for the other mall anchors. Now you'll note my mall anchor also built around the same time if not as old as any of these, in 1986, was assessed at $70.80. Now, regardless of any of my appraisal process and how I developed that and what the eventual value was, we've got a separate issue here, right? In that this mall anchor is not uniformly assessed with the others. You can see it's almost directly tied to building age as well, where 1986 has the lowest assessment, 1990 is a little higher, and then 96 and 95 are even above that. So for this one to be at $70.80 a square foot without any notable renovations is a separate issue beyond the typical appraisal process. Other common disputes. Recent sale, and Nora touched on this earlier. Was there any leased fee status that went along with that sale? Were the lease terms and the cap rate considered to be market level if it's an investment grade property? Was the sale within the last 3 years? That's the typical cycle in Illinois for assessments. Some jurisdictions are 4 years. Was the property exposed to the market? So one of the biggest ones here where you have these recent sale disputes is when you're dealing with build-to-suit transactions. So it was not exposed to the market. The buyer was always the buyer. Before the construction started, it was going to be sold to this buyer, and it was built, and the sale price is based on the construction costs. That doesn't pass the standard of market value as it wasn't exposed to the market, and it doesn't pass any of the principles that go with a market-based transaction. Other examples, tenants purchasing the building from the owner, especially if there was remaining lease terms, as those may have needed to be amortized as part of that process to get a sale done. Now, on the flip side of it, a retail strip center, 4 units, all of them with leases signed in the last 3 years. Market level occupancy at 92%. Sold after 8 months on the market at a market level cap rate. That seems like it ought to be a really good barometer for what the market fee simple market value is for that property. And I've seen these requests come through more often than any of us care to, where there's a sale, 2 years ago, and it was exposed to the market, and it did have market occupancy, and it was at market leases, and there's no secret sauce that to fee simple it. That's what the market value is. That's the fee simple market value. So that's something to keep in mind. Lease fee versus fee simple, kind of dug into that a little bit. Sale leaseback terms, a recent lease on the property, traditionally leased versus owner occupied properties. Was it build to suit? Here's another thing to keep in mind. A build to suit transaction doesn't have to happen within the first year, right? It could be an original lease on that building, and it could be in year 9 of a 20-year lease off of a build-to-suit lease, and then that lease fee interest sells. And someone might think, well, that lease is 9 years old. Well, okay, it was still purchased based on the constructs of a lease that was based on the construction cost and not a market-exposed lease. Now, you can have speculative construction, right, that leases to the market. You see that more in the industrial market, right? We built this building, we don't have anyone to occupy it, but we have this land and we think there's going to be demand. Now it's built, now it's offered for lease, and someone offers us a certain amount of money that we think is appropriate for this space. That seems like a market level lease. That's a different animal. The one that really stands out, I guess there's 2 of them. One I hit on here was Jewel. A number of properties sold throughout Chicagoland as sale leaseback transactions with 20-year leases attached to them. And I have seen assessing jurisdictions submit those as part of evidence. I'm not speculating. I've seen it happen with no adjustments, no consideration, and basically pleading ignorance to utilizing that data. And that's just not good enough. Nothing about that. First of all, it's a portfolio that's being sold. Second of all, that's not exposed to the general market. And thirdly, it's a sale leaseback. Jewel is still occupying them. None of that passes the test for fee simple market value in the state of Illinois. So here's an example of an appraisal that I reviewed, where we're looking for the market value of, the old term is the sticks and the bricks. I said here the site and the improvements of that site, where I'm reading an appraisal that I'm reviewing. And this wasn't the first time, but it bled into the valuation section, where the focus wasn't that this was a family style single tenant restaurant building. It was Denny's, and it was mentioned specifically that it was Denny's throughout the report. And then we get to the cap rate selection, and all we're listing is restaurants, and we're comparing it to a Denny's operation. That is probably fantastic for lending purposes that you considered those, because that's what an investor for an investment value is going to consider. This is fee simple market value. The fact that Denny's is the occupant should not be anywhere near this portion of the valuation. And then you see at the bottom where we're comparing tenants, not properties, which is a big mistake for this type of appraisal process. Other common disputes, just a simple difference in value opinion, right? Maybe the taxing body's emphasizing uniformity. Maybe there's a recent sale. Maybe there's other comps specifically in their jurisdiction that they're applying. And then maybe the flip side of that is the market is different. I see that a lot, especially in more rural states, where they get a property that really has a regional demand, but they're just applying the best sales that they have in their specific county, right? And that's not their fault. That's kind of almost their job, really. But when you're looking at a fee simple market value and the buyer pool could be across 8 states, they're just not set up well for that. So that's where it's almost always going to end up in needing a third party appraisal. And from there, what you hope is that they're amenable to that and understand their own limitations and say, thank you, let's look at this and see what I need to understand. That's how the process should work. I know that's not always what we see out in the marketplace, but if it's done by an expert, it should be treated that way. So understanding fee simple versus leased fee, like I've already touched on, it's improvements in land only, right? We're not considering the operator positively or negatively. Consider all the improvements, including the site improvements. And really one thing, and this is more in your sales comparison approaches to keep in mind, we're not adjusting to the lease status of the property. Maybe the property is vacant. Maybe it's fully leased. Maybe it's 50% leased. Maybe it's $30 a foot and it should be $15 a foot. Maybe it's $10 a foot and it should be $20 a foot. We're really adjusting in the sales comparison approach for the leased fee comps based off of our conclusions in the income approach. Because in the income approach, we establish what the market should be. So we want to adjust these leased fee sales to market. Now here's an example. Our first 3 sales here are leased fee transactions, right? $600.14 a square foot, $402 a square foot, $650 a square foot. Our next 3 sales are vacant restaurant, vacant Applebee's, former Baker Square, right? Good information. Now there's nothing wrong with saying who is in the building. That helps the reader, or who was in the building, because it helps understand the construction style. What we don't want to do is focus on the operator and adjust between operations, right? And we sense a trend here. Those other 3 sales that did not have long-term leases attached to them, 370, 250, 258. This is a compelling data set. It shows us a lot of information. It shows us trends. This should lead us to say, well, the value is most likely somewhere between $246 and $369 if that's the only data available, because those are the fee simple transactions. Definitions, those are important to understand, not only for the fee simple aspect, but more importantly, the market value as defined by the jurisdiction that you're working in. You can always add context, but make sure that it's just context and it's not changing the way that you're viewing the definition of fee simple, right? In the middle here, I've got an example where an appraisal cited an IAAO position paper. First off, there's our issue right there with that adjective, right? Position. They're taking a position. By definition, there's inherent bias there. It's not a fact. It's by definition an opinion. So right there, you're already confusing the reader and possibly yourself as to where your target is with this appraisal. Fee simple sales, we want to get sales that require the fewest number of adjustments or the lowest gross percentage. And it's good to look at those, right? And don't pigeonhole yourself into either aspect of it. It's just good to know what the net adjustment was and the gross adjustment is, because at times you could have something that requires an 80% gross adjustment, but a 5% net adjustment. That's a great comp, because maybe though that 80% gross adjustment is quantifiable and it's only 2 adjustments, right? What we don't want to get into is this sale only had a 30% gross adjustment and a 2% net adjustment. So it's a great comp. It might be your best comp. It also might have required 7 adjustments. So at the end of the day, what was really comparable about it? If I had to adjust, even if it's slightly, if I had to adjust for 7 different factors along the way, what was the hallmark, right? What was the benchmark for what makes this sale specifically viable for my process? And I will say, I mean, I've had appraisals in the past where you have one of those and you're not giving it much reliance, but there was one thing about it that was specific, right? Maybe you had the one grocery store that also had a gas station on that site, so you wanted to include it. It's just more about understanding everything that you're presenting and understanding the why behind it, and then paying that off, right? Let your reader know what was the thesis behind this data set, right? Was it size? Was it location? Was it date of sale? What are the benchmarks for what's most important about the valuation of this property? And what we really should be focusing on is what the buyer thinks is most important, right? We're trying to mimic the market. So what is a potential buyer going to consider? What would they consider to be a reasonable substitute, right? The theory of substitution should be paramount through your land sales, your building sales, and your lease comparables. Now, a sufficient number of sales to support the value conclusion, that's all that means, a sufficient number. Maybe it's 3, maybe it's 10, right? There's no magic number for the number of sales. What's compelling? What do you need to analyze? What helps support the value conclusion? And just a note there, closed sales versus leases, these are retrospective valuations, right? Now, if that listing was available as of the valuation date, maybe that's compelling, because maybe what we're trying to say is this land value is $2.50 because here's my 4 sales that support it, but also here's 2 lots in this business park that were available as of Jan 1, 2021 for $3 a foot. So what do we know? it wasn't worth $3. If it was, those would have sold, right? The more common sense, the more base level knowledge that you can present in the appraisal report, the easier that you can present that to a board of review in 15 or 20 minutes, to the PTAB officer in, an hour or two. And frankly, the less you have to start off with when you get to PTAB, right? I could have a PTAB hearing where my presentation lasts 30 minutes, or I can have a PTAB where my initial presentation lasts 2.5 hours. Just be effective with what you're presenting. Formatting. So this is getting in the weeds on the actual appraisal. I don't know that we have a lot of appraisers in the room, but obviously we have a lot of users of appraisals. So this is going to be important when you're looking at those and when you're working with your professionals and understanding what needs to be there. We have to have a scope of work to be USPAC compliant. We have to have a definition of value, which you should be using the state of Illinois definition of market value when you're doing work in the state, and not FIREA's definition, right? Be mindful of those intended users. I'll touch on again, as Bruce touched on it earlier. Who are you naming and why? And are you naming them with purpose, or are you just trying to make it easier on yourself? We've all had those requests. Well, list PTAB, list board of review. Okay, now they have rights to that appraisal, right? That's important to know. If you're giving them rights as an intended user, they have them, right? You might have a client that, is the property owner, and then the other intended user is the law firm. Well, if another intended user is the board of review and another intended user is the PTAB, what stops them from having all rights to that report the same way the law firm would, right? It's right there in the appraisal report. So just understand who you're naming and what rights you're transferring to them when you're doing it. Always focus on the real estate and the fee simple interest. Some of the semantics that I see as pitfalls, you're appealing the assessment, right? Not the taxes. You're not appealing the tax levy. That's not what we're doing here. We're just focused on the property. And then understand your definitions. Here's a couple examples of those. It's kind of interesting, in my opinion, just to see the nuances throughout different states. I've listed here Illinois, Iowa, Nebraska, Indiana. Obviously, I've already touched on Indiana as probably the most unique with market value in use. So the front end of appraisal report, you want to define the subject property. You want to talk all about the site, the building, and the improvements, and not the tenant, right? Not the business operations. Note anything that is relevant. If there are any differences between the photos and the valuation date, obviously they need to know. And now moving on to the market analysis. Avoid fluff. Make sure you're defining your market, right? And proving to the reader why that is the market for this property, and always keeping the importance on how this is helping someone understand the market value for the subject property. I know we've all seen an appraisal report with 40 pages of market, right? And where does it always start? Again, I'm speaking to Illinois people here. Where does it always start? Chicago, right? And let's drill down to Chicago. And at the end of the day, we had a 10,000 square foot industrial building in Crystal Lake. And you're asking yourself, interesting, what are the people in Hyde Park? How does that influence this industrial property in Crystal Lake, right? But it's all in there. Don't do that. Consistency. I know I see this as an issue in reports that I review, and I know it's always something that I'm mindful when I'm writing my own reports. If you're going to say something about the property, it should be consistent all the way through. If I'm in this description of the improvements and I'm describing some functional obsolescence, then I need to see functional obsolescence taken out or addressed in the cost approach. From there, that should also go into my highest and best use, right? A lot of these aspects of the report are tied together. physical life, economic life and age, those can vary. Just tell us why, right? Give us that information. The approaches to value, Bruce hit this right off the bat. You know, the appraiser is going to determine the scope of work and what approaches are relevant and necessary. And from there, when you're determining your data, you know, the example that I give here is a single tenant property should have single tenant comparables, because that's what the buyer would be looking for, right? If you determine that the most likely buyer for your single tenant building is another owner user, then they're probably not looking at a shopping center, right? They're looking for a single tenant building. Now it could be the opposite. If the most likely buyer is an investor of a multi-tenant industrial building, they probably don't want to carve up a big square into units and cut out pieces, right? Now we're getting in the weeds of what's really comparable. Highest and best use. It's really paramount to the valuation. I know this isn't maybe something that is germane to the normal processes that attorneys and tax reps are going through, right? They're worried about the value. They're interested in the value. They're appealing those things. But it's important that these things are defined in the appraisal report and fully vetted. So when you're hiring people and they're doing these appraisals for you, make sure that that's in there. You know, I'm sure Bruce, like myself, has seen something where it gets to the board of review and the highest and best use is a paragraph. And okay, maybe 2 out of the 4 aspects of highest and best use are covered, but not all 4. And there's not really a conclusion, or there's a conclusion for commercial use, right? Which is not really a conclusion. So you're telling me what could be built here is an industrial, multifamily, hospitality, retail, right? Recreational property. It's somewhere in that genre. We have to do better than that in defining it, because how do we come up with a market value conclusion without that, right? If we don't know what should be built here. And then compare it to what's built there right now. That's going to help you understand whether or not your property has obsolescence or not. Moving into the market analysis, I already kind of touched on that. Connect this section to your valuation, right? Make sure that the market that you're using for your comparable data set is tackled in the market analysis section, right? If all of my properties are in one town, then I want to talk a lot about that town in my market analysis. If it's across 5 states, then I need to kind of touch on the 5 states somewhere in there, right? Moving into the approaches now. Cost approach, we have to have a land value should mirror the highest and best use is vacant, as we just said. And be mindful of consistent use when you're valuing the underlying land. An example I would give for this specifically, maybe you've got a property that the highest and best use as improved is to maintain the current use, but everything around it has been redeveloped for alternate uses. But you've looked up the land value and you've valued your subject property, and the subject property as improved is worth more than the raw land. So the highest and best use as improved is continued use. But maybe this is a retail property and all the land surrounding it that's sold is multifamily property, right? Consistent use means we need retail land values underneath this retail building. Otherwise, we're not mixing them, right? So that's what I mean by mirroring your highest and best use and consistent use in valuing the land. Replacement costs, make sure you're using the appropriate Marshall and Swift valuation date, right? One pitfall, especially if you're making a really, retrospective request, right? Maybe right now something fell through and you need a 2018 or a 2019 appraisal done. Make sure that your appraiser's pulling the old Marshall and Swift and not putting in the 2022 Marshall and Swift numbers. there's multiple depreciation models that you can use when you're doing the cost approach. The first one that I think most people are familiar with is the breakdown method. And it literally is what it says, right? We're breaking out the physical depreciation, and we're talking about physical depreciation versus physical life. How long can this building stand? Then we're tackling functional obsolescence next. You can, evaluate that based off of a life cycle reduction, cost to cure, or simply a rental loss factor. And the same with external obsolescence. That's more market-based. It's outside of the property. And the most typical and common in a cost approach is going to be economic age life method, right? This is how long this property could operate the way that it stands for this use. This is how old it is, or this is where it's at in its life cycle right now. I've included a chart here for one of the ways to look at this. This would have been a mall property appraisal, and to determine the economic life cycle for regional malls, we looked at Midwestern malls that have been demoed or redeveloped or closed, right? That's a great way to determine an economic life cycle. It's certainly going to be more compelling than I looked at the back of Marshall and Swift, and this is what it says. The market extraction method is the most time consuming. That's the third option if you're doing depreciation. Here's a chart here that basically shows what you're doing is you're taking a recorded sale, you're subtracting out the land value to get to the remaining value that was attributed to the improvements. And then from there, you're taking out depreciation for what the cost was, right? The remaining improvement value versus replacement cost. And then you've also got chronological age. This one here, what makes this methodology difficult is that's not how the property was purchased, right? That buyer didn't do this math. They didn't buy that property saying, well, I know the land's worth this, so the remaining, I'm willing to pay this much for this remaining building, right? So it's more of a support and a visual aid, but it is transactional based. Moving on to the sales comparison approach, which I've really touched on a lot already. Understanding the how and the why between the adjustments and not using rules of thumb. That's how people get tripped up on the stand by good attorneys is, why'd you make this adjustment? Well, it's bigger. Okay. What's your evidence that it sells for less? Now, economies of scale. Okay. And do you have data to support that? Well, yeah, it's bigger. No. Do you have data to support that? Is the market showing you that that's what's taking place? Well, and now we're hamstrung, right? Here's an example of locational support that I used for regional office property where I had regional sales, right? My subject property was in Des Moines. I was doing the property as 1/1/2019, so I had Q4 2018 average gross rents. I compared them across each of my property types using CoStar Analytics, and that's how I adjusted for location. Quantify your adjustments as best you can. There are some jurisdictions that actually require it outside of the state of Illinois, Iowa being the main one that comes to mind. Provide them as much information as possible. If you feel that your valuation is correct, you should not be shy in sharing good information and rationale. This isn't a game. It's not a trick. As we really touched on at the top of this, if it was, Bruce and I wouldn't be presenting together, right? Most of his work is on the board of review side, and most of my work's on the appellant side. And here we are today, together presenting this information. This is not a trick. It's not a game. We should all be working from the same playbook. Now the income approach. Direct capitalization, it's a single date, it's a single moment in time. Stabilized occupancy in Illinois, the standards market occupancy at market rates. We've already touched on that. The one thing to note there at the bottom is everything works together, right? If you feel that a property has a really high vacancy rate, a really high stabilized vacancy rate, we're already starting to trickle down that risk, right? Because we're saying it's only going to be 75% occupied, right? It's not as risky of a proposition for me to meet that standard as it is 95%. So that's something to keep in mind. Now, where's our rental rate at, right? We've got all of our market data. Maybe we've got some listings as well. You know, if we're at 70% of the listings in the area, right? If the listings are at 15 and our concluded rental rate is at 12, again, we're lowering that risk, right? But if we're saying that our property is really good and we're going to be meeting and achieving the asking rents in the area, that's a little riskier proposition. Just make sure that they're all in concert. You don't want to see something where, you know, we're at the low end of the market rental rate and we're at the high end of vacancy and we're at the high end of the cap rates. Well, that, you know what I mean? Like that doesn't make a lot of sense. Are you the worst at everything? That's unlikely. That's an unlikely scenario. Comparable data support, understanding the lease structure. I think most people are pretty familiar with that. So in the effort of conserving time, I'm going to move through that one. Support your vacancy rate. Survey data can be good. Peer properties can be good. There are a lot of ways to get through that. One of the ones that I see a lot in the reviews that I do is the expense side, right? There's really two components, right? We've got the income and we've got the expenses, and everybody spends so much time getting signed leases and listings and really supporting the rental rate figure. And then it's just, you know, the market, right, for expenses. We're not looking at comps. We're not really using any support other than market principles for expenses. You know, why spend so much time doing such a great job establishing this side of the income approach and next to nothing on the other side? So hold yourselves to a higher standard on that end. That data is more available now than it's ever been. Cap rate support, you can use market participants, investor surveys, peer comparable sales obviously is the best. One thing about when you're doing fee simple, the band of investment takes on an added value, right? Because it's independent of all these other things in terms of a fee simple number. There are CMBS loan terms available from TREP, CoStar, that people can access to support each number of the abandoned investment model. And understand how to do the tax load, whether you're doing it based off of vacancy for a net lease property, or ideally if you're doing a full gross rent, and how to properly load the tax rate. And what that does is it's isolating it, right? The more we can do to isolate the taxes and just get down to the market value independent of those, the better off everyone is. So now I'm just going to go through really, some examples here before we open it up to questions. Here's one, an incomplete highest and best use, which I touched on earlier, right? Subject zoned this, physically suited for this, and based on the zoning and the analysis, it's industrial use consistent with zoning. And the existing use are all of these things. So we're not tackling any of them individually. We're not giving any support to any of those 4 factors. We're just simply stating things. Again, this is litigation ready appraisal. I'm not saying that wouldn't be good enough for most financing appraisals or almost encouraged, right? There's just a different standard here today. The incorrect definition of value, right? Here's the definition of value in the state of Missouri. And here's the opposing appraisal used the dictionary of real estate appraisal. It hurts your credibility. Is it going to get your appraisal thrown out? I don't know that it's going to be to that degree, but depending on what court you're in, it could do that. Here's an example missing the land value, right? We've got 5 comparable sales for this 15,000 square foot retail building that range from $68 to $150 a square foot. After adjustment, the appraisal report concludes that the value of this property is $85 per square foot of the building area, or $1.275 million. They did the sales comparison approach and the income approach. They both support that value. Now that same property type, let's say it's got a 5-to-1 land to building ratio, so it's got 75,000 square feet of land area. And the land sale data, which was omitted from that appraisal, shows that along this heavily traversed road, those are between $22 and $38 a square foot. And if we conclude $25 a square foot for that underlying land, $1.875 million. Missed the boat, right? Insufficient analysis. So this is a case where we've got a spread of our comparable data from 176%, or in this case, 144%. Not saying these weren't the best available comps, right? That's not what we're analyzing here, but what we are admitting is that's a pretty wide spread. And it's not just that you're just giving me plus minuses along the way, it's that we end with plus minus and equal, right? I don't know how to reconcile this at all to any level of an intended user with our spread that large. If this spread was between $50 a square foot and $58 a square foot, and we were just using plus and minus, could that be reasonable? Absolutely. But to reconcile between 108 and 300, I don't think we can do that. And that now here, similarly, rather than the symbols, we've got upward and downward. Now we're getting into the appraisal review aspect. Here's an excerpt from an appraisal review. Developing and reporting this, that blank, who does not have an MAI or any other professional designation. First of all, that's not a requirement to be an appraiser, and it's certainly not a requirement to be a competent appraiser. So we're already off to a bad start, and we're judging this appraiser solely based on their designation. Prepared the appraisal and value conclusion. Therefore, it is questionable at best, based on blank's qualifications included, that they are competent to prepare an appraisal. You are reviewing the appraisal report for its contents and merits, not the appraiser. This is in clear violation of that. And if you're an attorney and you see this, please submit this to the Appraisal Institute. That's not me saying it. That is me having called the National Appraisal Institute offices and discussing this specific situation, and then asking me to tell people to let that be submitted to them. That doesn't mean this person that wrote this review is going to get thrown out of the appraisal profession, but to quote the person I spoke with, we just want to help educate them so that it's done right. You know, don't always think of turning someone in or submitting their work as you're policing them, right? Other than simply bettering the profession. Now, does that review include an appraisal? There's appropriate ways and inappropriate ways to insert new data into your review. And there's an example of it. Understand the difference between an opinion and a USPAP violation. That's another thing that I spoke with the national office about that some appraisers struggle with, right? Claiming everything's a USPAP violation. Are you a USPAP instructor? Do you have expertise in USPAP? There are USPAP specifically, we're not talking about all of the add-ons, but the actual USPAP document. There are not that many things that you have to do to comply with it. So you need to be very careful about things. A great example for us today is this second one, where the reviewer claims that the appraiser failed to cite the following required intended users. That's literally non-existent. There are no required intended users. So right off the bat, this person's credibility is on the line because they're not even understanding what an intended user is, let alone criticizing someone else, saying they don't know what it is, and also claiming that they violated USPAP. So keep that in mind when you see these reviews. These are just kind of overviews, draw from experience, use concrete examples when you can, understand the local market, understand the people that you're writing the report for and what they're going to see and what their tendencies are. A lot of that falls on case law. Every part of the process reflects back to the intended use and the intended user, and that's really the point here today. Financing appraisals are written for their intended use and to their intended users, just like ad valorem appraisals are, and they should be treated that way, right? Look at it from the flip side. If someone wants to buy a property, or no, I'll say it this way. If someone wants to refinance their property and they had an ad valorem appraisal done as of 1/1/2020 to appeal their taxes, the financing body is not going to accept that for a number of reasons, right? But they're not going to accept it. It wasn't the intended use, and they're not the intended user. Why would the other side think that it's okay, right? If you ever need, to get that point across, please put it that way to them. And I hope that we can all understand that. Fee simple is the base. So beyond that, intended use and intended user, a least fee appraisal should never be submitted for a fee simple valuation. And at the end of the day, the appraiser defines the use and users, and a third party that gets their hand on that appraisal has no right to change those.
Okay, so I think we are going to start off with some questions here. If you have any questions, please put them into the question box on the right side.
While we're letting the questions come in, I'm going to kick us off actually, because Nora had a slide where she referenced that the standard for PTAB was the preponderance of the evidence, and the standard at the appellate court was clear and convincing. So my question is to Bruce, does the Board of Review have any specific standards, or do you talk about those, or just give us an idea of where that group falls, since we've already been told today where PTAB and the courts are?
Oh, Bruce, I think you're muted. Hold on. You should be unmuted now.
Can you elaborate on that a little? P standards in terms of what, how appraisals are submitted?
I was just curious if Board of Review thinks of anything in those terms, right? Like there's a clear standard at PTAB that it's a preponderance of the evidence, and there's a clear standard at the appellate court that it needs to be clear and convincing. I was just not sure if the Board of Review has an overarching standard, or if you discuss that, or if that's even something that comes into play.
Well, Kane County might. I think there's 102 boards of review, and they're all allowed to adopt their own rules and procedures, so it can vary. What I find is a lot of boards of review don't want to necessarily adopt specific rules regarding really anything. They don't want to tie their hands. I mean, they want to be able to get as many data points as possible. So, that they can keep it broad and keep it sort of within their discretion and judgment. I haven't seen very many rules that spell out what the standard of review is at boards of review. But if any county board of review did have one spelled out in their rules, it would be Kane County, I would think. Bruce, have you heard anything?
You think, yeah, you think Mark would have that spelled out? Yeah, you're probably right. I just lost you on the screen here. To answer your question, I don't recall, us having a specific training on that or anything like that. Like these are the standards and whatnot.
Yeah, I think the boards of review, the statute says they're supposed to provide an independent review of the assessments, and they're supposed to correct assessments as just and equitable and so forth. So they can take any kind of evidence they want, give it the weight that they think it deserves, and make a decision based on that.
Yeah, I mean, I think I touched on this in part of my presentation. And when we've been presented with appraisals that didn't have, Pete mentioned loading cap rates. Well, an ad valorem appraisal should always use the loaded cap rate method, because your taxes determine your NOI, which in turn determines your value. But where the taxes come, it comes from the value. So it's kind of what I call the dog chasing the tail scenario. So you should be taking the taxes out of the equation entirely. We've seen appraisals that don't do that. We've seen appraisals with intended users and uses. We've seen appraisals with incorrect dates. And I don't recall anybody ever saying, well, we're going to throw this data out. And to your point, Nora, we'll look at all the data. We try to, give as much weight as we can. But obviously, for the reasons I just talked about, some things will be given less weight.
And here's a question. It says the Cook County assessor has started not loading the cap rate and also not allowing the real estate taxes as an expense in the income approach. Does that sound at all proper to you, either of you?
It might be like Bruce is saying, forcing your hand to make sure the cap rate's loaded.
So if you're not deducting it as an expense and you're also not loading the cap rate, wouldn't you arrive at a value that's too high?
Way too high.
Would
Yeah.
you believe that that's an equitable valuation process?
It sounds like it to me. I don't see how that would work. It seems like it's one or the other. If you're going to eliminate the tax encumbrance out of your pro forma sheet determining your NOI, then you should use a loaded cap rate. But if you eliminate it and use a regular cap rate, I don't see how that works. Pete, can you see a scenario where that would be valid? I don't
No,
know.
it's going to be way too high, right?
Way too high. Yeah.
Mary Kate, do you see more questions?
Yes, I
Yeah,
do.
I've
So,
got another question.
summary, would it be improper then to not load the cap rate, right? Or on a gross lease property? Or in some regard?
You kind of cut out in the beginning.
For the real estate taxes.
You kind of cut out in the beginning of your question. Can you repeat that, please?
Proper to not account for the real estate taxes in an income analysis, correct? Is what I think we're trying to get to.
If I'm doing an ad valorem assessment, type of appraisal, you should take the taxes completely out of the equation. Because how are your taxes determined? It's determined from your assessed value. So you're already making a presumption of a certain value if you include the taxes. So you take the taxes out, but then you load the cap rate to account for taking the taxes out.
Okay.
That makes sense.
Are you ready for the next question?
Go ahead, Sue.
Bruce, you said the appraisal should be as of the lien date, but as we know, sometimes people have used appraisals within the same triennial, same quadrennial, and they're filing it. Attorneys are filing it to exhaust their administrative remedies. What is your experience regarding these, and do you recommend it?
I would recommend that you get an appraisal done as of the lien date. If you are appealing the taxes for January of 2021, then you should have an appraisal date as of that date. When older appraisals are submitted, and it happens all the time, like I said before, nobody's saying we're going to throw evidence out. We will look at that evidence, but it's not going to be given much weight, especially if it's more than a year old, because markets change quickly, as you know.
And is that true for all types of property?
I would say so. I think your best bet is to because you're gonna be missing out on quite a few sales. So if you submit this past term that I served on, if you, in the case of some of these cases we did, there were appraisals that were submitted that were 2 years old. So you've probably missed out on at least a year worth of sales by doing that.
Do you
You're also
also have,
hamstringing your appraiser.
I'm sorry?
You're also hamstringing your appraiser. You know, I've seen that happen where somebody submits, you know, an old appraisal and, you know, a 2-year-old appraisal, and they, you know, they want you to appear at board of review, or usually not likely PTAB board of review. You're not going to answer questions about that valuation date. So obviously the board is going to say, well, what's your opinion value for 2020? I don't have one. It's a 2018 appraisal. What do you think the market's done? I don't know.
along the same line, Bruce, how do you feel, let's say on a 2020 data value, sales that occurred after January of 2020?
Oh, that's a good question, Sue. I mean, I sit on 2 different boards, and I think it just depends on, it depends. In general, I would say in King County, we're a little more lenient on that. We might go up to March or something like that, as long as all the sales aren't past the lien date. But if somebody starts, you know, if I see evidence submitted where there's an August sale or September, generally we'll tell people, well, yeah, obviously there's some changes in the market here. You should consider filing next year.
A good rule of thumb too is, was the property available, right? So if I'm using a sale in April for a January 1, was it available at least as of January 1? Maybe was it
The
even in
sale or
process?
the listing?
Right, was it listed, right? But then it just, you know, it didn't close maybe until March or April, right? But at least the market could have seen it. Another thing you can do with post-dated information is simply make a paragraph in your conclusion and say, hey, I'm also aware of this data, and I think that it supports it alongside my primary comparables.
Yeah, and I've seen people use later sales to support maybe a market conditions adjustment or something like that. There's certainly nothing wrong with that. If it seems to fall along the line of some, you know, like some type of linear regression, then that would help support a market conditions adjustment you made for sales prior to that date.
I have another question here. What is the support for the statement that that for vacancy cases, one needs an appraisal to be successful when bringing a case to court? So Nora, I think this would be a question for you.
Well, if you go to court and your argument is, I deserve to have my assessment lowered because the property was vacant, you know, the court's going to say, okay, what's your authority? You know, what statute are you relying on? What case are you relying on? And you're not going to find any statute or case. It's going to be, well, usually they do that. And, you know, usually they do that is not a legal argument. So I think the best position is to get an appraisal that takes into account the diminished value of the asset. And there are appraisers out there that have, you know, no problem looking at a chronically vacant property, or to, you know, look at a property as a retrospective value assignment and say, okay, when this thing was gutted down to the bricks and the studs, it was really worth this because it would have, you know, required X per square foot in order to bring it up to whatever it ended up selling for later. So getting an appraisal that concludes a value that's in line with the diminished value is the way to go. Just showing up with a vacancy affidavit to court isn't gonna get you anywhere.
Just a point of clarification from somebody. PTAB standard of review is preponderance of the evidence in market value cases and clear and convincing in equity and assessment cases. And I think Nora did touch on that, but just to make sure everybody's clear.
Right. So since the scope of the presentation was more so about appraisals and appraisers and appraisal evidence, then yeah, but that is a good point, which is why uniformity cases are generally not going anywhere, you know, because if the other side can point to one that's assessed higher on a per square foot basis, it's harder to prevail. And in other jurisdictions, that's not true. In Texas, Pennsylvania, things like that, you have a situation where uniformity cases really have teeth. But in Illinois, it's harder, and part of it is because the standard is clear and convincing rather than preponderance of the evidence.
Are commercial appraisers concerned about the fact that our Cook County assessor is reporting them to the IDFPR? Any impact of the threat of reporting?
Oh, well, I can say from my standpoint, I've got nothing to hide. I mean, we do things to USPAP standards, and if he's reporting people, more than likely it's because they're doing some unethical things, like some of the things we touched on. If there's any hint of advocacy on your appraisal report, then you can expect to get reported. I don't know, Pete, what's your view on that?
I mean, that's definitely a solid point there in terms of whether or not, like, I personally worry about it. No, because I'm not doing anything unethical. What I do worry about for the appraisal profession and the health of the state are township assessors that submit every single appraisal that comes across. And this isn't hearsay. I've literally seen the receipts of certain assessors that do that. It's in clear contrast of what's supposed to be taking place. In fact, you could certainly probably try those people on whether or not they're trying to circumvent the appeal process for the public.
Mary Kate, can I chime in too?
Yeah.
It wasn't long ago that the IDFPR was pursuing attorneys for the unlicensed practice of appraisal because of the tax appeals they were filing. And so at that time, I did a very extended deep dive into the disciplinary proceedings of the IDFPR into appraisers. And I got to warn everybody, before you turn someone in, I just want you guys to know what kind of thing you're unleashing on these people. I mean, there's no judgment involved. Any report that they get, it's like a dog with a bone, and they pursue these people. And I called all of these people and I was like, so what happened here? I noticed that the IDFPR and you and da-da-da. I mean, these people wanted to talk to me for 90 minutes sometimes. I mean, they were thrilled that anyone would just listen to them process their trauma. I mean, it was, $5,000, $10,000, $15,000 in legal bills. I mean, so this is not like something you should take lightly and say, well, they broke the rules, I'm going to report this. I mean, can be, career ending for some of these people. So that's my 2 cents on that.
Also,
It's also
along
not
the,
appropriate for the state to be dealing with this.
Well,
probably been-
prosecutorial discretion is a thing. You don't have to go after, bring me felonies, don't bring me misdemeanors, right?
I mean, I had a call, this is probably 8 years ago, and the officer had 2 questions. Both the answers were in the report. They just didn't read it. And the case was closed in a matter of 5 minutes. But imagine the amount of man hours that went into that until they finally called me. And it was all because of one deputy assessor that was submitting every commercial appraisal that came into their township. That's highly inappropriate and honestly, well outside of the lines. And I know it for a fact because I had another assessor send me the email where he bragged about it.
there's a problem there, and the impact is that people get less comfortable. I've had a couple phone calls from clients wanting to know if I'm comfortable testifying at PTAB, that they know of other appraisers they use don't want to testify at PTAB. Why are they not interested in testifying at PTAB for situations like you're just describing? I've also had conversations from people, phone calls from people to find out what's typical for an appraiser to do in gathering data for a certain type of property in the market, because sometimes when the state reviews these files, they don't know what's typical.
We have another question. What about submitting an update letter from the appraiser in that situation? And I think that this is regarding the question about lien date. Does a letter of update satisfy the requirements of an appraisal, or?
I I don't think so. I think that requires a new appraisal. Would that be right, Pete?
Yeah, I mean, I'm not really sure. Do you mean an update letter from the attorney or from
No,
an appraiser?
appraiser. It's
So
been,
that's not even a thing, right? An update letter is not, it's not USPAP compliant. It's not, it doesn't exist. You can have a restricted appraisal report that is shorter than a full-blown report. You could have a very shortened, concise summary appraisal report that you submit. But if you're putting something on paper with a value, it's got to have a work file.
Bruce,
So
what kind of data would you want to see in that scenario?
You mean like if we're talking about the update situation, what kind of data would we want to see? You know, I can think like what Pete was saying, you know, there should be, if, from a USPAP standpoint, I don't care if you're at a cocktail party, if you're an appraiser and you tell somebody their house is worth $400,000, you just gave them an appraisal.
Mhm.
And they can use that information against you if they should suffer some kind of loss because of that statement you made. So to Pete's point, if you're going to writing a letter of certification, I hesitate to use the word certification, but writing a letter saying that you know, you've
With a
updated the
conclusion.
value. Yeah, you've just provided an appraisal. So if that, to answer your question, Sue, if that we on the board level, we'd want to see another appraisal, at least something. I mean, some.
So let's say a restricted report with 5 new comparable sales. How would that sit with you?
I think that would be fine. I mean, as long as it's well supported and you've got the work file to support it, I don't see any reason why that wouldn't be accepted by the board, but simply making a statement on the letter would not suffice.
This is a good one, and it's from somebody who works at the Cook County Board of Review. They said, Bruce, as a Board of Review member, how do you handle the knowledge of knowing that practitioners shop around for the lowest opinion of value via a preliminary value report?
I've seen preliminary value reports being submitted as evidence in the boardroom, and you know, that's you know, that's a big risk for both the appraiser and the appellant submitting that evidence, submitting that report as evidence, because clearly it's going back to what we said in the beginning: intended use, intended user, all that kind of stuff. Shopping around for the lowest value, you know, I mean, if the appraisal is well supported, you know, it's kind of like Pete said in the beginning, we're all trying to get to the same end goal, and that is to make sure we've got proper assessment in place and everything is equal, fair and equal. So, you know, I don't have a problem with that necessarily, but as I said, I wouldn't do it as an appraiser. I think it puts the appraiser at risk as soon as you put that information out there.
And I also don't, as a practitioner, I don't think that's necessarily true. I think attorneys are looking for what's going to be most cost effective for their clients, and for different, Nora and I have talked about this extensively in the past. For different asset types, you seek out different types of appraisers that are appraisers with different types of experience. Nora, if you want to touch more on that.
It depends. Yeah, it just depends. Jurisdiction, asset type, the likelihood that it's going to go to hearing. You know, these are all factors that help you recommend the best expert for every case. You know, cost benefit analysis being what it is, it's not like formulaic. It's just something you learn over time. You know, what works in one place doesn't work somewhere else, and someone who is compelling in front of one tribunal may not be compelling in front of another one. Someone who's talented and very experienced at writing a certain asset type may not be at a different asset type. Somebody who's willing to give like an update letter for a reduced cost, you know, may be a good choice as an expert in a jurisdiction where you know you're going to have to put something new in that second or third year, or fourth year of the assessment period. And other people who say, no, I'm just going to charge you for a full report, you know, they might not be a good fit for for that jurisdiction if you're trying to make everything make sense, because obviously the pie is only so big, the potential relief is only so big. You can't recommend appraisals that are going to cost more than how many tax dollars are at stake and so forth. So
And it too, you have to listen to your client. As an attorney, you have to listen to what your client wants to do. You know, you guide them, but
well, a lot of times they don't want the report
Conversely,
at
you're
all.
bringing the judgment to the table.
Well, a lot of times they don't want to pay for a report at all, and they want you to be the expert and the advocate, you know, and there have been times where I've had to show up at board of review hearings going, well, you know, a good cap rate would be this. I don't want to do that. You know what I mean? I don't want to. I like having an advocate and an expert. I think it's very effective.
okay. I have one question. Let's see. Can you highlight, I think this is for you, Pete. Can you again highlight the differences between what financing appraisals versus ad valorem appraisals really quickly, mostly related to tenant rent versus market rent, contract rent versus market rent?
Oh, sure. So if you're just talking about the rental aspect of it, if I'm going to lend money on the value of this property, I want to know exactly what's happening at this property at that given moment, right? I don't need a hypothetical market occupancy and market rates. I need to know your rates and your occupancy and what the risk is for that operation. Now it matters whether or not you have Kohl's in your center or Salvation Army as your anchor, right? It matters if your grocery store is Jewel or Joe's, right? Like all of that becomes germane to a financing appraisal, whereas it all goes away under the standard of market occupancy at market rates, where that anchor is now anchor, right? And we look at all the different rental rates that all different type of anchors have signed in the past couple of years. Maybe you've had that anchor in for 12 years and they're signed for another 13, right? So the only rent that matters for that space is the rent they're paying, right? The bank couldn't even care less whether it's market or non-market. They're just like, that's the rent you're going to get for that space. What's the rent you're getting for the rest of the space? How risky is it? And that's what we're going to lend based off of. So it's really very dynamically different. It doesn't mean that very so often those can line up, right? Where we just signed the lease for this anchor last year and they're paying market rents and the rest of the strip mall is market occupied at market rents. Now all of a sudden those values can be very similar.
Does that go across the board, Pete, with things like leasing commissions, vacancy rates, reserves for replacements, date of appraisal? Are all those factors going to change if you change your function of the appraisal?
They sure can, right? I know, let's take office as an example. I've seen some office buildings that have exorbitant expenses, contract expenses, because maybe they clean more often than the rest of the market does, or they just have so much dead space. They have a giant lobby, whereas another one's more efficiently built. And that's going to be something that's more important, where if I'm doing at a market basis and I've got 5 market expense comps that are all within a tight range and my subjects double, I'm kind of hamstrung by the market data. I get that you spend a lot of money on utilities, but I can't prove it. So it's not, something that I can move forward with.
All right, so I think that's the end of our questions. Thank you very much. Bruce, do you have any closing remarks you'd like to make?
Well, it was an honor to speak for you. Thanks for inviting us. Really appreciate it. It was fun.
Pete?
Yeah, appreciate you having us.
Thanks for being here.
Yeah.
Thank you very much.
When is your presentation before the IPAI?
Ooh, it's on a Monday.
In April?
It's a Monday in April. Let me
Oh, yeah.
pull open Outlook. I turned it off so it wouldn't make a bunch of noises. We are Monday afternoon, April 4th.
Perfect.
Also, this is a 3-part series, so you guys are going to get emails for the other 2 parts. And we hope you can enjoy it, and we hope you got a lot out of it.
Thanks. Okay, so thank you everybody for participating today, and we'll, like Sue said, we'll fill you in. If you're an attorney, make sure you fill out the survey at the end. If you have any ideas for future webinars and different education programs, please email me. My contact information is available on propertytax.com, or you can email the general mailbox for WPTA. Thank you so much to Nora for putting so much work in the legal concepts, and Bruce and Pete, again, thanks so much, Sue. Again, thanks, and that's it. So attorneys, fill out the survey and you'll get your CLE credit. We were just approved for 2.25 hours, so we're good. Bye.